I have listened with a lot of interest to the intervention of the Honourable Prime Minister and the other honourable members of the National Assembly who followed his intervention. I have also listened with a lot of interest to the trip down memory lane that Honourable Ivan Kolendalu embarked upon. And I must say that he has said a few things that I would tend to agree with. For instance, when he made reference, and he said that in French, if I quote him, comment peut-on demander au judiciaire, the Judicial and Legal Service Commission, de nommer un membre de l'exécutif? You see, that is an admission on the part of a seasoned member of the bar, as well as a seasoned member of the National Assembly, whom I have a lot of respect for. Basically what he's saying, and that is indeed, for me, a very important thing that I ask friends on all sides of the House to take note, that he is saying that the nomination of the Director General is in fact the nomination of a member of the executive. So that is où le bas blesse. And if he says that the Judicial Legal Service Commission cannot proceed avec la nomination, he therefore agrees that therein there is a problem. And there is therefore the need, because when I've listened to everyone, there is the need for us to find another method by which such a nomination can take place. But then again, the Honourable Prime Minister has, in a very intelligent manner, refrained and not responded to the following question that exists in the members of the public. And the question is as follows. Why remove the Director of Public Prosecutions from the whole equation? That is the question. Because the least that I would have expected, and the least that a civil society would expect, is for the Honourable Prime Minister to come here today and tell us, has he had consultations with the Director of Public Prosecutions? Has the government not thought it fit that there should have been consultations, if it was not for him, for any other reason? He may have not to want to meet the DPP, but shouldn't the DPP have been consulted at least by the Attorney General? Shouldn't the DPP have been consulted at least by le Secrétaire du Cabinet or the Solicitor General? And if such consultations did take place, what was his reaction? This is what we need to know. Because we have all been talking about the powers of the DPP, according to some members of the House, eating away some of the powers of the DPP. But we are therefore entitled to expect that a government that respects the provisions of the Constitution and understands the parameters and meaning of the word consultation would at least tell us whether they have met with the DPP and shared views, and if so, what were his views? And if they haven't met with the DPP, why not? We expect to know. You see, Mr. Speaker, sir, let me quote a very important person in this legislature. He said a few things and I listened very carefully and wrote down verbatim what he said. I quote, "In fact, Mr. Speaker, sir, when I looked at the case file, because, he said it twice, when I look at the case file, all the evidence, I say all, and I'm speaking as a lawyer, they are not only damning, all of them goes in one direction. There is absolutely no contradiction from police officers and other witnesses." Those are the words of an influential member of this National Assembly, the Honourable Prime Minister. The words that he pronounced this morning. And it is very important to analyze those words in the context of the presentation of this bill. the Honorable Prime Minister makes reference to him having seen the case file. What is the meaning of a case file? And I observed the Honorable Prime Minister went across the recording, paused, went back, paused, looked at each shot. I must admit you were well dressed this morning as you are now, so I enjoyed watching. But that was not the reason why I was watching you, sir. The reason I was watching is because what you were saying, cela m'a interpellé. Because then I saw you lift a file which was not in front of you, where you were reading from. I saw you lift another file and said, when I look at the case file, and then he held the file. So my question is, sir, what is the case file that he was referring to? Because the only case file I know, because he said he was speaking as a lawyer. As lawyers, you see, he's had a very successful career as a politician. And to glorify his successful career, he is now Prime Minister. Congratulations. I've spent more time at the bar practicing as a lawyer. So all lawyers, as he would know, what is a case file? A case file is in fact a police case file. If it is not, tell me the contrary when you have the time to intervene and clarify. Because right now, in my mind and in minds of the public, you said you saw the case file. And I equate case file with a police file. And you went as far as to say, I say all. I'm speaking as a lawyer. All the evidence. So he saw all the evidence. What is in a case file? In a case file, there lies evidence. It is not in the Prime Minister's file that you have evidence, it's in the police file. Therefore, if the police file has evidence, how the hell did it end up in front of the Prime Minister's hand? How? Therefore, it is logical to conclude that he has had access to the police file. If I'm wrong, forgive me. But this is what it says to me. Because he said, I saw all the evidence. He went on to say, there is absolutely no contradiction from police officers and other witnesses. Therefore, the Prime Minister has had access to witnesses' statements in order for him to say there's no contradiction. How can he have access to witness statements if it was not remitted to him by the Commissioner of Police? Think. I pause. I shudder. Because this means that the general rule provided for in the Constitution that says that the role of the Commissioner of Police is not to be under the control of any authority, but to simply, if at all, take general policy issues. The Prime Minister, that's all he can do to the Commissioner of Police. General policy. But general policy does not mean that he can go and see what witnesses' statements contain. So, general policy does not mean that.
I got your point.
Good.
And
I tried to make it legible.
You are concentrating too much
on the Prime Minister?
The subject is you have a bill.
I'm coming and explaining, I'm connecting it now.
You've taken almost 5 minutes.
Very good. I've got 5 minutes extra because Honorable Kolendavelu granted me that.
So I'm afraid.
Oh yes, he did. Oh yes. Oh yes. Oh yes. Oh yes.
I'm afraid you're wasting your time.
No, I'm not wasting my time. It's my speech.
Go directly to the bill.
I am being relevant.
My instruction, go directly.
You can't instruct me what to speak about. This is my speech, not yours. Now, as I'm saying...
Come on.
Come on what?
This is lack of respect to the chair.
I'm telling you...
I am giving you my ruling. You have to concentrate on the bill.
I am.
You have been talking too much on that point.
Okay.
Whether you have a point or not, the Prime Minister will reply to you.
Okay.
But you're concentrating too much on that point, and you keep on discussing with the chair.
So you understood, so I will move on, therefore.
Apologize for that first.
I apologize for whatever you want.
I am happy you apologize.
Do you want me to apologize for anything else? Tell me. I'll apologize as a series.
Apologize for what you did wrong.
Okay. In advance as well? Anything. Tell me.
Apologize to the leader of the opposition.
Oh, he's a good friend of mine. You're not. I don't have to apologize to a friend. He's a friend. I don't need to apologize. To you, I apologize. Since you're not a friend. You are taking my time. You are taking my time.
Apologize and continue.
I'm not apologizing again. I've done enough of apology.
You have
Come
already
on.
apologized.
I've already done it.
Okay,
You love the word.
Go ahead.
Record it.
Go ahead.
Play it over and over again.
Oh, come on. Now you're going too far. I'll
Apologize
stop
again?
you. I'll stop you. Mind your language, and you should know that you're talking to the chair, and you have respect.
Yes.
Apologize once more.
Apologies. Happy?
Very
Thank
happy.
you. So I am. So am I. So why do I connect the Prime Minister with this bill? Because he has an aversion, and he has expressed his aversion, for the office of the Director of Public Prosecutions.
Express any aversion for the office of the DPP. In my answer to the question that was put to me this morning, I have only stated the facts with regard to workplace. But what is it? What you want? You're a barrister now. You want to? So the honourable member cannot say that I.
Are you the speaker? No. Are you the speaker? He's talking to the speaker? No. He's talking to the speaker. He looked at you. Apologize. You apologize. Yes. You better do that.
So, Mr. Speaker, sir, on
Wait.
a point of order, I have not expressed any aversion.
Oh, what is happening? Please, leave the house. Leave the house. Disrespect, leave the house. I am ordering you to leave the house. I am ordering you to leave the house. I am ordering you to leave the house. I am ordering you, Sergeant at Arms, do your work. Please, go take some fresh air. So there was a point of order.
I was saying, Mr. Speaker, sir, that I have not expressed any aversion to the office of the DPP or to the DPP himself. What I was replying to a question this morning, I was only stating the facts of the case.
So I heard this point, so don't refer to that. Please go to the bill.
I'm going to the bill. That was not a point of order. That's a point of explanation, and I take it. I will try to.
You have
move
your own
on.
opinion.
I'm entitled to it.
You know, the Prime Minister has got the right to make a point
I'm saying
of order.
I'm moving on, sir.
I am the Speaker.
I'm moving on.
And you're doing the work of the Speaker.
I'm moving on.
You're eating your own time.
You are eating my time.
You are eating your own time.
So let's eat it together.
So, this is the last warning I'm giving you. Try to behave yourself. This is the last warning I'm giving you.
Yes, sir. So let me now refer to a very important document. And here, where I differ with the Honorable Colin Dabelou, is as follows. You see, he goes on to explain that from his understanding, the DPP is not above the law, and he goes on to justify the Prosecution Commission, and he goes on to justify that there should be the possibility of having judicial review, and that was the whole purpose. But then again, you know, let me refer to your ruling, sir. To your ruling.
You don't have to refer to my ruling.
That's part of my speech.
You don't have to refer to my ruling. You don't have to refer to my ruling. Make your speech.
But that's part of my speech, sir.
Make your speech directly. Don't refer to my ruling. This is my instruction.
Okay.
Go and
So
read the standing orders.
I will not refer to your ruling. I will not. So according to Erskine May, I'll refer to Erskine May. In any debate, a member is required to declare any relevant pecuniary interest or benefit of whatever nature. Not only pecuniary. Whether direct or indirect, that they may have had, may have, or may be expecting to have. I think that as a seasoned member of the bar and of this assembly, the Honorable Kolendavelu should have declared his interest, since he has a matter pending before the ICAC. And I would agree with what's in Erskine May. Now, how many members on the other side have to declare their interest? So the issue is not, therefore, who can prosecute or who will not prosecute. That is not the issue. And therein, you see, when my late father used to say, in their madness there is method. Let me say what he meant by that. You see, the issue here is not who is entitled to prosecute, who is not. It's not that the issue. Because I agree with the Honorable Prime Minister that the DPP retains the right to discontinue proceedings. I totally agree that Section 72, subsection 3, B and C, je n'ai pas de problème avec. But the issue is, with the coming up of this law, let us go and break down for all to understand what happens. All members of government who have any inquiry pending against them at the level of ICAC will obviously have to face the law as it is today. The matter will have to be referred to the Director of Public Prosecutions. From memory, it's under Section 82 of the Prevention of Corruption Act. Because the authority that has le dernier mot, whether to prosecute or not, is indeed, under the actual law, the Director of Public Prosecutions. But with the advent of this law, it will no longer be a constitutional position, that of the DPP, that decides to institute proceedings. He will no longer have that power. He will no longer have access to the file. He will no longer have the right in this statute to call for the file. No, it will be a political appointee chosen by the Prime Minister with the stamp of the President and supposed consultation with leader of the opposition. Hello, I've decided this. There we go. Thank you. So with the advent of this new law, many will be saved by the gong. Through the operation of statute. Can you imagine, sir, what the Honorable Prime Minister is proposing? That if the DPP decides not to go ahead, to discontinue proceedings, to stop proceedings, he will have to give explanations. And there will have to be, he can even have judicial review. But if the Director General does not institute proceedings, no explanations. So if he does not institute proceedings against Honorable Kolendavelu, no explanations required, no judicial review, no aggrieved party. If he does not institute proceedings in the Molnupiravir matter, he does not institute proceedings in the Grand Bassin matter, in everything concerning whoever reported there. There are so many, I can't even remember them. The Kisnen matter. Everything. You can't go for judicial review. If the Prime Minister is serious, why does he not return it to the DPP to be the sole authority to decide? He owes an explanation to the country. Why not? And when the Honorable Minister of Social Security comes up with recommendations internationally, I listened to her. She said supposedly what they were doing was under the cover of recommendations. Wrong! It has never been recommended that the DPP should be removed with that constitutional right to decide, to prosecute, to institute proceedings. So what will happen, therefore? So right now, I'm happy that Honorable Kolendavelu said clearly, and I will say those two things. Honorable Kolendavelu said clearly that for him, even if there is a provisional charge, the DPP, with this new proposed legislation, will have a right to intervene and take over. I agree with him. Because this is what the law says. Because this is what authorities say. This is basically what is the proposition in the case I will quote. And those are the cases of Lee Wai-Chong versus ICAC, the case of Dvorsky versus Croatia before the European Court of Human Rights, and most importantly, the case of Assange, of the European Court of Human Rights, which clearly state, very simply, that proceedings start from the moment that someone, in Mauritius at least, is provisionally charged. Proceedings start then. Therefore, if proceedings start then, I agree with Honorable Colin Davelou that the DPP will therefore be entitled to intervene from the moment there is a provisional charge, and you can't stop him. However, where the problem lies, how can the DPP intervene in the blind, in the dark, when he does not have the file? He has no right to call for the file. Therefore, if the Prime Minister agrees with Honorable Colin Davelou, unless he disagrees, if he agrees with Honorable Colin Davelou que le DPP peut intervenir du moment où il y a ce qu'on appelle a provisional charge, that he clarifies that in the law. Make it clear that the DPP is entitled to intervene. At least if he doesn't want to clarify it, say it here for posterity, for Hansard to print it out, and for any superior courts later on to see the intention of the legislator was not to remove that right from the Director of Public Prosecutions. But if the Prime Minister refuses to, he will therefore confirm there's disagreement between him and Honorable Colin Davelou. If he refuses to clarify, he will confirm there's disagreement between him and Honorable Colin Davelou. Which is which? Deux sons de cloche au sein d'un gouvernement. But then, Honorable Colin Davelou talks about judicial review. In the case of Malhotra versus the DPP, this is a case Honorable Colin Davelou should know, Honorable Obigadu should know, Honorable Ganou, who's not here, should know. In that case, it was clearly established that going for judicial review against the decision of the DPP, not to prosecute or to discontinue, all this, it is not an appeal decision, and the court cannot replace the DPP. It is only the process, the legality of the process that is being reviewed. This is judicial review. So let us not fool the people by making them believe that judicial review means that. Judicial review of a decision, and it is established by the Privy Council in the case of Moit. It does not mean that you can come and replace by another decision the decision of the DPP. It means that the law lords or the judges can only go as far as to decide on the legality of the process. That is judicial review. Et non pas comme une cour d'appel pour renverser la décision. Alors, Monsieur le Président, the Prime Minister, in my view, will have to explain to the people how, according to Section 66 of this bill, and this is something which is really worrying, Section 66 of this bill, where it says there is no need for reasonable suspicion. Section 66(1), that surveillance is allowed. Honorable Utim and other friends talked about that. And what is the description of surveillance? The definition of surveillance, which is at Section 66, 8b of this clause, of this bill. Surveillance means the continual act of monitoring, observing, listening to a person. Est-ce qu'on peut comprendre ce que le Premier ministre nous propose, Monsieur le Président? Monsieur le Premier ministre vient de l'avant avec le support de tous ses autres collègues, ministres et députés. Il vient de l'avant pour justifier qu'il est autorisé sans avoir de raison, sans avoir de cause raisonnable, sans avoir reasonable suspicion, sans cette nécessité, parce que cela n'est pas précisé in subsection 66, clause, subsection 1. Without the authorization of a judge in chambers, it can go and surveillance with listening to someone. And where does it say here? From a public place, with the likely result of obtaining private information about that person or another person. Ça veut dire que you, them, us, people outside, they will be able to listen on to what we say and without reasonable suspicion. If the Prime Minister disagrees with me, why does he not, just like in the subsection 2, where the word reasonable grounds are used, why are reasonable grounds not used in subsection 1? Why the difference? So you go to the judge in chambers, you tell the judge in chambers, now I've listened, now I've monitored, now I have listened without your permission, and I want now your permission to go and investigate even further. Listen and even closer. This time you're going to have bedroom buddies. Even your bedroom they can come in now. But there, here, in a public place, you're walking along, they can record you. You're talking on the road, they record you. Without the permission, and it doesn't say here, for the purpose of preventing, detecting an offense. But il n'y a pas de reasonable suspicion now. It can be an innocent person. So they come and say, oh, I just want to detect. But one again, this is the Prime Minister who tells us that he does not want to do anything against human rights. But if he's serious, there's no reason not to believe him. Why doesn't he come and clarify his intention by adding the word reasonable grounds? Why does he not come and tell us that we have the right to apply for judicial review against the decision of the Director General? Do that at least. But then again, the whole ploy of this government, is to ensure that cases are stuffed in a drawer and that their prosecutions never happen at the eve of general elections. That is the ploy of this government. If Machiavelli wanted to know what was Machiavelli, but they could come here and see before them. We have fantastic people here that show us how to be better than Machiavelli. Under the guise of statutory provisions, they remove the DPP from the equation solely to block prosecution. If that is why I say, when Erskine May says that Honorable Colin Davelu, my reading, should have declared his interest. Once upon a time, in 2015, he was Vice Prime Minister. And he rightly called me to order when he said I should have declared my interest and not put a question on the BAI affair. He was right, because I was a lawyer in there, and I bow to what he said. But if he said it to me, he forgets that he should give himself that advice? He forgets that then, when it suits him? Then he forgets. I look up to him. And I'm sad today that he has shown that for some bizarre reasons, he has forgotten the lessons he gave me. In those days, in 2015, I spoke to my late senior, Shakeel Mohamed, and he said, Ivan Colin Davelu was right. You should not have talked about this because you were a lawyer there. That is the respect a senior counsel had for another senior counsel. And today, où sont les principes? Où sont les leçons? La démocratie, on le détruit quand on le veut. La démocratie n'est pas nécessairement et seulement simplement le droit de voter ou le droit d'exprimer son opinion. Mais ce n'est pas d'appoint the political friends in order to cover up cases. That is the point problem. And when you look at a document published, and I will conclude on that, published by the European Union, you see, whatever I'm saying is going to be entering one ear and then going out of the other ear. What I'm saying here today, this law should not even be in the hands of any Prime Minister, including the next. The next Prime Minister, Ramgoolam, has no right to have a law like that at his hands. Watch my words. He has no right to have this, because you know what? The difference between you and I, sir, the difference between you and I, friends, is that I am not someone who basically changes my tune because I'm in the opposition or government. I say that no Labour Party government is entitled to have a law like that. No MMM government, no alliance government should have this despicable act in their hands. It should be thrown out. It should be kicked out. And we undertake to throw it out. Because when the European Union, in the Venice, when it says in Strasbourg on the 15th of March 2011, what did it say in the Venice report? it says at page 6 of that report, the Venice Commission goes to talk about political interference in prosecution, like here. The report points out that that if modern Western Europe has largely avoided the problem of abusive prosecution in recent times, this is largely because mechanisms have been adopted to ensure that improper political pressure is not brought to bear in the matter of a criminal prosecution. The Commission points out that in totalitarian states or in modern dictatorships, criminal prosecution has been and continues to be used as a tool of repression and corruption. However, as the Commission states, the existence of systems of democratic control does not give a complete answer to the problem of politically inspired prosecutions. Mauritius is creating history indeed. It is not about political prosecutions. It is about political cover-up. Thank you very much.